Will the House please come to order and members kindly take their seats? Good morning. The devotional today will be led by Howard Coffin, who is an author and historian in Montpelier.
Good morning. I stand this morning in a bastion of freedom. In this grand room on March 9th, 1865, the General Assembly ratified the constitutional amendment that outlawed slavery in this nation. The vote was 217 in favor, none opposed. Here, the legislature, in effect, declared war on Nazi Germany even before Congress had acted. I was so proud the other day to join the standing ovation for that student who had been jailed for doing what all Americans are supposed to do. We must lift our voices, act in opposition to oppression. Thus it should be, partly because 250 years ago today, Fort Ticonderoga was in Green Mountain Boys' hands after they had seized it in the morning darkness of May 10th, 1775. It was America's first offensive action of the Revolutionary War. And with the quick capture of nearby Crown Point, George Washington had the cannon to drive the British out of Boston. Ticonderoga at the Champlain Narrows and a quick portage to Lake George and on to the Hudson River was the key strategic location on the Champlain Corridor. And that corridor from the St. Lawrence River to New York City suddenly was the most important warpath in the world, and it was in our hands. The Americans strengthened the defenses at Ty, particularly by fortifying a promontory on the Vermont shore they christened Mount Independence. This strong point would hold off the British for 2 vital years. And when Ticonderoga and Independence fell, American troops soon bloodied a force of the King's men in the hills of Hubbardton. Then a hastily raised army under John Stark, with a great deal of help from Seth Warner and the Vermonters, defeated a Hessian-dominated British supply force just west of Bennington. The stage was set for the decisive victory of the American Revolution with the defeat of John Burgoyne's army at Saratoga. What an important role Vermont had played in the great victory for independence. Always Vermont, this place of peace, has risen to the challenges defending human rights sometimes requires. I first came to the State House nearly 60 years ago as a reporter. Daily devotionals then were almost all religious. Remembering that, I close in these newly troubled times with words I have found down the long years in Vermont soldiers' letters. I call Psalm 121 the Vermont Psalm. From it, these words that might have been recalled during the bold approach to Ticonderoga's dim, forbidding walls early one mighty morning a quarter of a century ago, they were probably spoken quietly. I lift up mine eyes to the hills, from whence cometh my strength, from the Lord who made heaven and earth. Thank you.
Members, it's hard to believe, but it is a page's last day. So good morning, everyone. It's so wonderful to have our guests here with us, and I'm honored to thank and acknowledge the third and final class of Legislative Pages for their important contributions to the 2025 legislative session. As Pages, you have played a crucial role in carrying conversations and information that spurred the creation of bills later to become law. As a group, you work together and were stewards of the building, guiding visitors, supporting legislators and staff each and every day. Your time under the Golden Dome has made a lasting impact, and each of you brought your unique backgrounds and skills to help make the 2025 legislative session a success. Just like those who came before you, you are now an invaluable part of our legislative family. I hope your experience here has been enriching and that you have had the chance to learn, explore the building, and immerse yourself in the legislative process. I hope you formed meaningful relationships with each other and legislators in the building, and that you'll stay connected with this institution in the years ahead. On behalf of all members of the House, we wish you the very best in your future endeavors, and we hope that you will come back soon to visit us. Thank you so much. We'll now recognize the Pages. I'll present the pin. We'll take a photograph. If you could please keep your applause to the very end, and we'll thank them again. So first, we have Austin Boulanger of South Burlington. There we go. Next, we have Eleanor Brady of Williston. Next is Atticus Lawler of East Montpelier. Next is Braden Sharon Burns of Montpelier. Next is Naomi Isla Siegel of Woodstock. Next is Oscar Volte of Brattleboro. And last is Alex Young Springer of Burlington. Let's give these Pages one more round of applause. Are there any announcements? Member from Montpelier.
Madam Speaker, you heard a devotional today from a rare man and a Vermont institution, Howard Coffin. A seventh generation Vermonter, Howard is the author of 4 books on the Civil War. Something Abides, Discovering the Civil War in Today's Vermont. Full Duty, Vermonters in the Civil War. 9 Months to Gettysburg, and The Battered Stars, as well as Guns Over the Champlain Valley, a book on military sites along the Champlain Corridor. Howard was born in Woodstock, but now resides here in the capital city. Howard has long been a significant force in the restoration of the Cedar Creek Room in particular, and has loaned many items from his own personal collection to the State House and gifted many more to the Vermont Historical Society. Would you please help me welcome him to the People's House today?
Will the guest, the member from Montpelier, please rise and be recognized? Are there any further announcements? Member from Cornwall.
Thank you, Madam Speaker. I have a constituent visiting today from the great town of Cornwall. Tanya Biker is not only a professor at Middlebury College, but serves as our town's select board chair, sorting out issues from snow plows to pickleball courts. Could you help me welcome her to the People's House, please?
Will the guest of the member from Cornwall please rise and be recognized? Are there any further announcements? Member from Shelburne.
Madam Speaker, I invite one and all to join the newly formed Bloom Crew, which will be planting flowers and shrubs in a newly tilled garden on the State House's west side. Please meet outside of the Lieutenant Governor's office at 2 p.m. Flowers, shovels, and dirt will be provided.
Are there any further announcements? Seeing none, orders of the day. Members, we will begin with House Bill 481, which is an act relating to stormwater management. The bill passed the Senate with a proposal of amendment that is printed in today's calendar. Member from Burlington.
Madam Speaker, the Senate made some overall positive revisions to House Bill 481, and the House Committee on Environment found the report favorable with a straw poll of 11-0. I'll briefly review the changes that were made. I'm following along in the action calendar from today. In the first section of the bill, there were a couple small changes made requiring the Secretary of the Agency of Natural Resources to provide notice to all owners who are subject to the 3-acre rule permit requirement. Changed the name of municipal impact fee to municipal special assessment fee. Then moving on to page 2862, links this section here in subsection 928 to the later study that we put in the House bill on municipal stormwater utilities, and includes financial assistance to municipalities to help them design or receive engineering services necessary for the formation of a municipal stormwater utility should we create municipal stormwater utilities, which we'll be studying as part of this bill. On 2864, there's a check back report added to make sure that we're looking every few years at the clean water surcharge to the property transfer tax to ensure that it is still an effective use of resources. And then here on the same page, there are a couple changes in section 8, subsection B, asks that the secretary prioritize properties that are subject to the 3-acre permit when awarding municipal stormwater implementation program or developed lands implementation program funds. And then the most significant change that the Senate made to the bill is section 9, helpful plain language stormwater management public resource guide for property owners. And then on to the next page, the final section, section 12, they slightly changed our study title to include the term, the phrase on stormwater management, and overall improved the study on stormwater management and the potential for municipal stormwater utilities by adding a representative of a regional planning commission and a representative of a municipality with a designated downtown that is served by water and sewer infrastructure that is not subject to an MS4 permit. And then made a few changes to the study to include to clarify and include some items that are really valuable.
So the question is, shall the House concur in the Senate proposal of amendment? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have concurred in the Senate proposal of amendment. Next is Senate Bill 53, which is an act relating to certification of community-based perinatal doulas and Medicaid coverage for doula services. The bill was referred to the Committee on Health Care, which recommends that the House propose to the Senate to amend the bill as printed in today's calendar. The member from Bristol, Representative Cordes, will speak for the committee. Affecting the revenue of the state, the bill was then referred to the Committee on Ways and Means, which recommends that the bill ought to pass in concurrence with the proposal of amendment recommended by the Committee on Health Care. The member from Georgia, Representative Brannigan, will speak for that committee. And then carrying an appropriation, the bill was then referred to the Committee on Appropriations, which also recommends that the bill ought to pass in concurrence with the proposal of amendment recommended by the Committee on Health Care. The member from Putney, Representative Maricki, will speak for that committee. Please listen to the second reading of the bill.
S53, an act relating to certification of community-based perinatal doulas and Medicaid coverage for doula services.
Member from Bristol.
What is a doula? Madam Speaker, may I quote the Sunrise Report of the Vermont Office of Professional Regulation?
You may.
A doula is a trained, non-clinical, non-medical support person who provides direct emotional, physical, educational, and informational services to birthing persons before, during, and after labor and childbirth. Doulas provide birthing persons continuous companionship and emotional support during labor, information about potential pregnancy, childbirth, and postpartum complications. They help with physical positioning and non-medical pain management techniques during labor, facilitation of communication between the birthing person and healthcare providers, and assistance with advocacy for labor and childbirth healthcare preferences. Postpartum, doulas continue to provide emotional support, information, and topics like breastfeeding, infant care, and coping skills, and may even help prepare a meal to support the family. Traditionally, doula services have required out-of-pocket payment with no public or private insurance coverage available. Thus, the services have been limited primarily to birthing persons of financial means, and many individuals who have the highest need for support do not have access to services that would lead to better maternal outcomes. End of quote. The United States has the terrible distinction of having the highest maternal morbidity and mortality rates of any higher income country, especially for Black women. The leading cause of postpartum death is suicide. Madam Speaker, may I quote Dr. John Kendall?
You may.
Dr. John Kendall, a pediatrician and researcher, once said, "If a doula were a drug, it would be unethical not to use it." Evidence clearly shows that doula services decrease C-section rates, decrease the rates of preterm birth and low birth weight, and lead to 57.5% lower rates of postpartum depression and anxiety. Untreated maternal mental health conditions, the most common complication of childbirth, have been shown to lead to poorer overall outcomes for birthing individuals, poorer long-term outcomes for the children of these individuals, and higher costs of care. Long-standing research efforts, such as the Cochrane Review, showed a 39% decrease in C-sections and a 15% increase in spontaneous vaginal birth, a 10% decrease in the use of pain meds and epidurals, shorter labor, and better APGAR scores for newborns, hence fewer neonatal intensive care unit stays. The Bixby Center and the National Law Center did a cost-benefit analysis of doula care that showed that there is more than a 20% reduction in the odds of a preterm birth for births that include doula support. Per this report, the estimated savings per avoided preterm birth is $41,964. Births with doulas have a 40% reduction in the likelihood of cesarean births. Average additional costs per C-section were $4,459. However, we know in Vermont that cost could be much higher depending on which hospital the C-section is performed. Birthing people with doula support have a nearly 35% reduction in the odds of experiencing postpartum anxiety or depression. A collaboration between the Vermont Department of Health, Support Delivered, and a research and data analysis group called Mathematica provided Vermont-specific data showing that there is a $48 million cost to untreated perinatal mood and anxiety disorders in the form of need for subsequent mental health and social service care, loss of worker productivity, and increase in absenteeism. 40 states are in the process of actively covering or have pending doulas or have pending legislation. According to the Doula Medicaid project of the National Health Law Program, as of January 2024, at least 13 states and the District of Columbia provided Medicaid coverage for doula services. Rhode Island and one other state also require commercial insurance coverage. TRICARE covers it. Google, Amazon, Walmart, and other large companies pay for it as a benefit to employees. There are significant savings to be gained by the use of doula services. And doula care is one area of healthcare that has an immediate positive financial impact. The services that doulas provide in near continuous contact with birthing individuals, unlike what patients experience with the rotating hospital staff schedules, provide immediate financial benefit to healthcare systems. Investing in compassionate and skilled community-based doulas brings a significant return on investment by preventing costly hospitalizations and procedures such as C-sections and stays in neonatal intensive care units. It also improves outcomes for the children of those births and saves lives. On to S53. Act 97 of 2024 directed the Office of Professional Regulation to review what the most appropriate type of regulatory oversight for doulas would be, and for DVA to determine a methodology and cost estimate for Medicaid reimbursement for doula services. S53 moves this work forward and provides the recommendations of OPR and DVA forward and creates a new chapter in statute. Madam Speaker, OPR completed its work and recommendations and compiled them into the Doula Sunrise Report of January 2025. OPR, with stakeholders, studied doulas in the context of Medicaid coverage and asked what form of the three types of regulation the Office of Professional Regulation uses would be most appropriate. Based on the study, the group overwhelmingly agreed that certification of community-based doulas was most appropriate. They did not see evidence of documented harms caused by doulas, and so this level of regulation provides adequate oversight for public protection without creating insurmountable barriers for doulas to attain certification. Registration and licensing are the two other forms of regulation provided by OPR. Registration offers no oversight, and licensing is unnecessarily burdensome for this profession. As for DVA's work, the Department of Vermont Health Access, they evaluated estimates from other state methodologies and developed a proposed reimbursement methodology for Vermont Medicaid. I will let the member from Appropriations discuss this, but I will mention that the methodology recommended a payment of $100 per visit, a minimum duration of 30 minutes, a service limit of 12 visits. And the words from our fiscal analyst, something to be aware of: people are going to get pregnant whether or not this program exists. We're not driving utilization. We're responding to a healthcare need. So you can find the bill, you can find the amendment, the House Healthcare Amendment to S53 on today's calendar, and you can find the full bill has passed by the Senate in the House Healthcare Committee page. Section 1 discusses definitions, and one important definition is to be clear that what we're creating with S53 is in a new statute, a doula that is called a certified community-based perinatal doula. And they must be certified. Community-based doulas also, by law, by S53, will provide doula services specifically to under-resourced and marginalized populations at low or no cost, often through a community-based agency. More on the certification, going down to prohibitions and penalties. Certification is not voluntary. If you want to be a community-based doula, you must be certified, and you must go through the process that OPR will work to design to become a certified community-based doula. You can still practice as a non-certified doula, but that would be without the benefits that certification provides, including Medicaid reimbursement. Duties of the director. This is the director of the Office of Professional Regulation. The director will provide information to doulas and the public, grant and renew certifications, provide regulatory oversight and discipline, administer certification fees, and commence the rulemaking upon passage of this bill. And note here, the Office of Professional Regulation plans to utilize an external certifying body for the certification of these doulas. Next section, advisor appointees. The Office of Professional Regulation will appoint community-based doulas as advisors with specific requirements regarding years of experience and that they be actively practicing. And the advisor model is just one model that OPR uses. It is a less, it's formal, but is not as complex as, for example, the board process, such as the Board of Nursing. Eligibility, the bill will continue by outlining eligibility, renewal, and unprofessional contact processes. These are all typical to the work of the Office of Professional Regulation for other professions. Section 3 formally adds community-based doulas to the OPR statute. Section 4 adds the initial and renewal fees, which the member from Ways and Means will discuss. Sections 5 and 6 outline Medicaid reimbursement for community-based doulas. And this, again, is the information that was provided to us by DVA. Sections 7 and 8 in the bill as passed by the Senate, they were amended by our House Healthcare Committee. And again, you can find the amendments on today's calendar. DVA and the Office of Professional Regulation were steadfast partners in the process of developing certification and reimbursement and offered helpful recommendations to House Healthcare Committee for these amendments. One of the requirements in order to provide Medicaid reimbursement for sort of community-based doulas is that the state of Vermont request a state plan amendment of the CMMS, the Federal Centers for Medicare and Medicaid Services. That process can be lengthy, and so the amendments allow for more time for this process. On to the amendment of House Healthcare. As I just mentioned, We wanted to give the Department of Vermont Health Access more time to apply for this state plan amendment and for the process to work itself out. So there's a change in the date. Not later than July 1st, 2026, DVA will seek a state plan amendment. And then the effective date was changed in that Medicare coverage for doula services shall take effect either on July 1st, 2026, or upon approval of the state plan amendment requested to Section 7 of this Act. Your House Healthcare Committee took testimony from the Deputy Chief Counsel, Office of Legislative Counsel, General Counsel, Office of Professional Regulation, and the Secretary of State's Office, the sponsor of the bill, the Deputy Secretary of State, Principal Fiscal Analyst, Joint Fiscal Office, Director of Communications and Legislative Affairs, Department of Vermont Health Access, a social worker advocate and doula from Washington County Mental Health Services, and the co-director of Doula Association of Vermont. Madam Speaker, your House Healthcare Committee voted favorably on a vote of 11-0-0, and we ask for your support.
And now for the Committee on Ways and Means, member from Georgia.
Thank you, Madam Speaker. S53, an act relating to certification of community-based perinatal doulas and Medicaid coverage for the doula services. Members have already heard a good summary of the bill, including background and details. So regarding the fiscal impact, Madam Speaker, on Ways and Means, we deal with numbers and tax policy. We cannot tell you if we need to have doulas or how to regulate their training. We can tell you how much it will cost if the legislature decides to implement the program as suggested in this bill, and the impact that it would have on state revenue. The bill proposes to establish a certification for community-based doula services during labor and birth, and the prenatal and postpartum time for people giving birth. The bill as recommended by the Committee on Healthcare does not make an appropriation, but the Office of Professional Regulations, OPR, over at the Secretary of State's office, would need $25,000 in fiscal year 2026 to cover the costs of establishing the certification program. 2026 starts July 1st this year. The amount would cover staff time, IT, stakeholder outreach, and rulemaking. There is an appropriation for this amount in the Committee of Conference version of H493. That's the big bill, the Fiscal Appropriation Act. The initial fee for doula certification would be $75, and the renewal fee, $120. Estimates show 70 to 100 practicing doulas in Vermont. Estimated application revenue is $4,500 to $7,500 in a fiscal year. I have copies of the Joint Fiscal Office report for S53 here at my desk if any members would like to see the complete report, but I can answer any specific questions if there are any. The Ways and Means Committee heard from the Deputy Chief Counsel and the Legislative Counsel, the Deputy Secretary of State over at the Secretary of State's office, the Principal Fiscal Analyst in the Joint Fiscal Office, and Madam Speaker, the Ways and Means Committee voted 10-0-1 to approve this bill as it came to us, and we look for your support, Madam Speaker.
And now for the Committee on Appropriations, member from Putney.
Thank you, Madam Speaker, and thanks to the members from Healthcare and Ways and Means for their pieces of this. As was just stated, there is a small appropriation of $25,000 that was not in the original bill, but has been added into the conference report for the fiscal year 2026 appropriations. Looking further down the line, as was just stated, there will be some expenditures in the coming years, but that will be determined as usage comes up. Not to repeat the fiscal report that was just given, I'll just go to share that we heard from Ledge Council and Joint Fiscal Office, and the committee voted 10-0-1 to approve this. When you ask your approval.
The question is, shall the House propose to the Senate to amend the bill as recommended by the Committee on Health Care? Member from Fairfax.
Thank you, Madam Speaker. If I may, I'd like to borrow a few lines from the great Frank Sinatra.
You may.
These little town blues are melting away. I'm going to make a brand new start of it in old New York. If I can make it there, I'll make it anywhere. Come on, come through, New York, New York. Now you may be wondering why I'm quoting one of the greatest walk-off songs of winners of all time. Well, my daughter was what many will call a COVID baby. During the uncertain and vulnerable time, my husband and I were incredibly fortunate to have the support of a doula, and I recognize that I am saying that of privilege. She also happens to be my cousin, my best friend, and truly my rock. For those of you who know me, calm is not usually a word that would come to mind. So when it was suggested by my doula that I make a playlist to keep me grounded during labor, I jumped on the idea. I was expecting my daughter to follow my stubborn footsteps and arrive late. But in true dramatic fashion, she came a month early. The only song that had made it onto my playlist was, you guessed it, New York, New York. With my doula by my side and Sinatra on the speaker, my daughter entered the world 12 hours later, like her mama, happy, healthy, and loud. Today, I recognize how privileged I was to have that support system. The United States continues to have the highest maternal mortality rate of high-income nations, and it's unacceptable. I proudly stand in support of S53 to ensure that every mother and parent, regardless of income level, has access to the kind of care and support I was lucky enough to receive. Thank you.
The question is, shall the House propose to the Senate to amend the bill as recommended by the Committee on Health Care? Member from Bristol.
Madam Speaker, thank you, member, for those powerful words. I want to make a clarification. I apologize, I misspoke. When it is true that if you want to be a certified community-based doula that is state certified, eligible for Medicaid reimbursement, that part is not voluntary if you want to seek that role. You can be a non-certified community-based doula. You can be a non-certified, non-community-based doula, and that is voluntary. Thank you, Madam Speaker.
So the question is, shall the House propose to the Senate to amend the bill as recommended by the Committee on Health Care? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have proposed to the Senate to amend the bill. Now the question is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and third reading is ordered. Members, we are waiting for one more bill reporter, so we are going to do, we'll take up S109 last, and we'll work through the calendar in order. So we'll now turn to House Bill 401, which is an act relating to exemptions for food manufacturing establishments. Member from Shaftesbury.
Madam Speaker, I move we postpone action on H401 until Tuesday, May 20th.
The member from Shaftesbury moves that we postpone action on House Bill 401 until Tuesday, May 20th. Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have postponed action on House Bill 401 until Tuesday, May 20th. Up next is House Bill 488, which is an act relating to the fiscal year 2026 transportation program and miscellaneous changes to laws related to transportation. Member from Bennington.
Madam Speaker, I move we delay action on 488 until Wednesday, May 21st.
The member from Bennington moves that we postpone action on House Bill 488 until Wednesday, May 21st. Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have postponed action on House Bill 488 until next Wednesday. Now we'll take up House Bill 494, which is an act relating to capital construction and state bonding. The bill was referred to a committee of conference on the disagreeing votes of the two chambers. The committee of conference has met and considered the same and recommends that the House adopt its report, which is printed in today's calendar. The member from Springfield.
Madam Speaker, the report of the Committee of Conference can be found in today's House calendar on page 2925. The Conference Committee voted unanimously for this report. When we went into conference, there was some differences from the original House version. The largest difference was that we, in the governor's original recommend, had about $3 million of bonded dollars that was to go to some projects in some communities that were not really state-owned projects for infrastructure upgrades. We felt on the House side that that was more appropriate for general fund dollars, and we moved the money to the big bill in conversations with our House Appropriations Committee. We also cut down the funding to $2 million. That particular item on the Senate side came back to the Capitol bill, still being funded with general fund dollars because the Capitol bill has bonded dollars and some general fund dollars. The other body upped the amount to $3 million instead of $2 million, and it was back into our Capitol bill. In negotiations in our conference committee, the House side agreed to keep it in the Capitol bill with general fund dollars, but at $2.5 million instead of $3 million. And we also put in language to make sure that our dollars go to a municipality or go to a municipality that has a long-term lease with a particular project. And we wanted to make sure the infrastructure is owned by the municipality. There were other changes that the other body put in terms of general fund. Into our Capitol bill, they added 3 separate projects that normally we do not fund through the Capitol bill. We, on the House side, wanted those dollars and projects to go back to our appropriations, general fund budget, and that was agreed to. The other body also cut some of our bonded dollars for some of our state projects. In our negotiations with the other body in our conference committee, we proposed to go back to our version on the House side for those dollar amounts for those projects, and that was agreed to. So, Madam Speaker, most of our House positions were upheld in the conference committee. And the report was unanimous from the 6 members, the 3 from the House and the 3 from the Senate. And I would ask that the House concur with our conference committee report.
The question is, shall the House adopt the report of the Committee of Conference on its part? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and The report of the Committee of Conference has been adopted. Member from Poultney, can you please offer us a motion to deliver House Bill 494 to the Governor forthwith?
Madam Speaker, I make a motion to deliver H494, the Capital Construction and State Bonding Bill, to the Governor forthwith.
The member from Poultney moves that House Bill 494 be delivered to the Governor forthwith. Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have ordered House Bill 494 to be delivered to the Governor forthwith. Next is JRH 5, which is a joint resolution authorizing limited remote joint committee voting through the remainder of the calendar year of 2025. This resolution has been read and appears in yesterday's journal. The question is, shall the House adopt the resolution on its part? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have adopted the resolution. Members, this morning, the Committee on Ways and Means reported favorably on Senate Bill 12, which is an act relating to sealing criminal history records. Member from Poultney, can you please offer us a motion to suspend our rules to take up Senate Bill 12 for immediate consideration pending its entry on the notice calendar?
Madam Speaker, I make a motion to suspend rules to take up S12 for immediate consideration pending entry on the notice calendar.
The member from Poultney moves that we suspend our rules to take up Senate Bill 12 for immediate consideration pending its entry on the notice calendar. Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have suspended rules to take up Senate Bill 12 for immediate consideration. Senate Bill 12 is an act relating to sealing criminal history records. The bill was referred to the Committee on Judiciary, which recommends that the House propose to the Senate to amend the bill as printed in yesterday's notice calendar. The member from Essex Junction, Representative Dolan, will speak for the committee. And affecting the revenue of the state, the bill was then referred to the Committee on Ways and Means, which recommends that the bill ought to pass in concurrence with the proposal of amendment recommended by the Committee on Judiciary. The member from Burlington will speak for that committee. Please listen to the second reading of the bill.
S12, an act relating to sealing criminal history records.
Member from Essex Junction.
Madam Speaker, S12, as amended by your House Judiciary Committee, which you can find in yesterday's calendar, it was sent by the clerk's office today at 9:26 a.m., and I believe there are also a few copies available on the pages desks for folks. So as amended by your House Judiciary Committee, S12 takes key steps to modernize the system for criminal record clearance in Vermont. For those of you who were here last year, the contents will likely sound familiar, as a majority of the bill is modeled after a bill passed in the House last year. Before getting into the details of the bill, I will offer some background information. The General Assembly has worked on policy regarding the expungement and sealing of Vermont criminal history records for several years to ensure that old records of nonviolent offenses do not unduly hinder Vermonters from obtaining jobs, housing, or educational opportunities once a sentence has been successfully completed. In policy development on this topic, the plan is to develop systems and practices that balance our goal of minimizing the collateral consequences of a criminal history record with our collective goal of ensuring public safety and minimizing the impact on victims. Currently, Vermont employs a two-track system for expunging and sealing criminal history records. I'll take a moment to outline the differences in these two terms, which can have different meanings across states. In Vermont, expungement refers to the deletion of a record, and sealing refers to the closing of a file to general access. In current law, whether criminal records are eligible for expungement or sealing is determined by the type of offense, the length of time since the person completed the sentence, and whether the court finds that expungement or sealing the record serves the interests of justice, among other factors. The current system is overly complex, the result of years of amendments and a piecemeal approach to the issue, and therefore is poised for clarification as proposed in the bill before you. S12 builds on recommendations proposed during prior legislative sessions, as well as those from the 2021-22 Joint Legislative Justice Oversight Committee to develop and improve record clearance process. The bill moves Vermont from a two-track record clearance system toward a one-track sealing process. Record clearance is an important part of our criminal justice system as it addresses significant barriers that exist for those who have been sentenced, specifically related to housing, employment, and educational access. A study in Michigan showed that people whose records were cleared saw an average of 25% increase in income within 2 years of clearance. In our current employment environment, individuals with long completed criminal sentences are finding it hard to find jobs and housing. 3 social factors that are correlated with the commission of crimes are unemployment or unstable employment, lack of support or inclusion in a family, and engagement in a community. When people have old, irrelevant records, this can prevent them from finding housing and jobs and exclude them from communities. We want to prevent this type of situation as it is counterproductive to our current public safety concern. When discussing our criminal justice system, it is always important to discuss racial disparities. A 2022 study by the Council of State Governments showed that Black and Brown Vermonters are 350% more likely to be charged with a misdemeanor, 600% more likely to be charged with a felony, and 1,400% more likely to be charged with a felony drug crime, despite no difference in drug use compared to white Vermonters. While we are considering measures to prevent these disparities, it is important for us to also address the harmful reality that currently Black and Brown Vermonters disproportionately have criminal records in our state. Record clearance is one tool we can use to mitigate this disparity post-conviction. While the evidence in support of record clearance is significant, there are different schools of thought in regards to the type of process used. As shared earlier, Vermont currently has a two-track system involving both sealing and expungement. S12 moves the majority of the record clearance process to sealing, with a few carve-outs remaining for expungement. Testimony shared in committee revealed some concerns around complete record deletion, such as found in expungement. Witnesses discussed the value records can hold for future cases. Even if old records are no longer serving as predictors of future crime, witnesses shared that these records can offer criminal justice purposes, including impeachment considerations and prosecutorial discovery needs. Additional witnesses shared the relevance records can provide for hiring and oversight of law enforcement. S12 moves towards a sealing regime in order to meet the goals of record clearance while also creating space to address this and other concerns. The streamlined process proposed also addresses system inefficiencies identified by witnesses. With a more efficient sealing regime, the expectation is that there will be increased confidence in the record clearance process and create new opportunities to strengthen the system in the future. In determining the qualifying crimes for record clearance, S12 followed the lead of last year's legislation and referred to the list recommended by the 2021-22 Joint Legislative Justice Oversight Committee. Many of the expanded qualifying offenses included in S12 have been considered by the legislature in previous sessions and were originally proposed to provide pathways forward for Vermonters in recovery from substance use disorder following justice system involvement. As will be shared in the bill section overview, the list of qualifying crimes consists of primarily misdemeanors and a limited number of nonviolent felonies. Now I will turn to reviewing S12 as amended by House Judiciary. For those following along, you can find the House Judiciary strike-all amendment to S12, as I said, on page 2759 of yesterday's House calendar, or through the email that was shared earlier. So starting with section 1. As an overview, this section amends the chapter adopted by the General Assembly in 2012 that sets forth the process for a person to petition to have a criminal history record sealed or expunged. In general, this section moves from a complex system of sealing and expungement to one of sealing in most instances, with an expanded list of qualifying crimes and limited access to sealed records for certain entities that require such records for criminal justice purposes. Subsection 7601 is the definitions section. The definitions of court and criminal history record remain as in current law. The definition of predicate offense is removed, that is no longer relevant. And the definition of qualifying crime is updated to include all misdemeanors except those listed and only the specific list of felonies included. As I did last year as well, I will spare the body of reading the full language of qualifying crimes, but I will refer folks again to the list in yesterday's calendar or in the email, and that is on pages 2759 to 2763 of yesterday's calendar, related to the list of offenses. In general, the misdemeanors that are excluded include listed crimes and those related to domestic and sexual violence. Again, those are the ones that are excluded. And for felonies, the ones included is specific to nonviolent and property-related offenses. Moving to subsection 7602. This sets forth the process for a person to petition for the sealing of a criminal history record if the offense is no longer a crime or it is a qualifying offense. It clarifies that whichever office prosecuted the offense resulting in the conviction, the state's attorney or the attorney general, will be the respondent in the matter, unless the prosecuting office authorizes the other to act as the respondent. Under this section, the court shall grant the order without a hearing if the petitioner and the respondent stipulate to the sealing. It is also made clear that the process is not available to an individual who is the holder of a commercial driver's license or commercial driver's permit seeking to seal a record of a conviction for an offense committed in a motor vehicle. Next, this subsection outlines the conditions that need to be met in order for the court to grant a petition of sealing for each type of qualifying offense. For offenses that are no longer prohibited by law, the conditions include that the petitioner has completed any sentence or supervision for that offense, and any restitution and surcharges ordered by the court have been paid in full, provided that payment of surcharges shall not be required if the surcharges have been waived by the court. Then, for qualifying misdemeanors, the conditions include that at least 3 years have elapsed since the date on which the person completed the terms and conditions of the sentence. Again, that restitution is paid, and then it adds that the respondent has failed to show that sealing would be contrary to the interests of justice. Now, for qualifying felony offenses, the conditions that need to be met in order to grant a petition to seal is that at least 7 years have elapsed since the date on which the person completed the terms and conditions of the sentence. Again, restitution, and that, again, the respondent has failed to show that sealing would be contrary to the interest of justice. And the last category is qualifying DUI misdemeanors. And the conditions for that are that at least 10 years have elapsed since the date on which the person completed the terms and conditions of the sentence. Restitution was paid, and this adds that the person is not the holder of a commercial driver's license or commercial driver's permit. And then lastly, that the respondent has failed to show that sealing would be contrary to the interests of justice. Lastly, this section clarifies that sealing a criminal history record related to a fish and wildlife offense does not void any fish and wildlife license suspension or revocation imposed pursuant to the accumulation of points related to that sealed offense. Points accumulated by a person shall remain on the person's license, and if applicable, completion of the remedial course shall be required. Moving to subsection 7603. This outlines the procedure for granting a petition when a conviction does not occur. In that case, unless either party objects in the interest of justice, the court shall issue an order sealing the criminal history record related to the citation or arrest of a person if the petitioner and respondent stipulate to the sealing or within 60 days after the final disposition of the case. If the court does not make a determination of probable cause at the time of arraignment, the charge is dismissed before trial with or without prejudice, or the defendant is acquitted of the charges. If a party objects to sealing the record, the court will schedule a hearing to determine if sealing the record serves the interests of justice. A person may file a petition with the court requesting sealing a criminal history record related to the citation or arrest of the person at any time. Subsection 7604. This section states that a court must wait to act on a petition for expungement if the person has another criminal offense pending. 7605 states if a petition for sealing or expungement is denied, the petitioner must wait 2 years before filing again, unless authorized by the court. 7606 retains the current law regarding the effect of expungement because there are still some areas of law, such as court diversion, where expungement is used. The House Committee on Judiciary added language to the statute to require a state entity that inquires about a person's criminal history record is to advise the person of the person's right not to disclose expunged records. 7607 outlines the effect of sealing. Except for certain circumstances where persons or entities are granted access to sealed records, a sealing order is legally effective immediately, and the person whose record is sealed is to be treated in all respects as if the person had never been arrested, convicted, or sentenced for the offense. In any application for employment, license, or civil right or privilege, or in an appearance as a witness in any proceeding or hearing, a person may be required to answer questions about a previous criminal history record only with respects to arrests or convictions that have not been sealed. The House Committee on Judiciary added language to the statute to require that a state entity that inquires about a person's criminal history record is to advise the person of their right not to disclose sealed records. Subsection C establishes who can use and under what circumstances a sealed record can be used. If a party who has been granted authority to use a sealed criminal history record pursuant to the exceptions established in the subsection wishes to use the record in a court proceeding, prior to any use of or reference to the record in open court or in a public filing, the party must notify the court of the party's intent to do so. The court will then determine whether the record may be used prior to its disclosure in the proceeding. If a party submits a filing that contains a sealed record or a reference to a sealed record, that filing must be filed under seal and remained under seal unless the court permits the use of the sealed record. This does not apply to a person using their own sealed record. Other entities will be able to access sealed records for specific purposes, including, and there's a list. An entity or person may use in any litigation or claim arising out of the same incident relating to the record, including use of the record in reasonable anticipation of litigation. A criminal justice agency may use, as defined in 20 VSA subsection 2056A, and the Attorney General may use the sealed criminal history record for criminal justice purposes. A defendant may use a sealed criminal history record in the defendant's criminal proceeding. Use of a conviction for DUI 1 may be used as a predicate offense for a penalty enhancement for any subsequent offense. A sealed record may be cited in a court order or decision. A sealed record can be used for firearms background checks. Prosecutors may use a sealed record to meet discovery requirements. The person who is the subject of the record and the person's attorney may use the record. A law enforcement agency may use a sealed record when considering an applicant for a law enforcement officer position or an investigation into a current employee. Persons or entities conducting research shall have access to a sealed criminal history record to carry out research in accordance with state law. Information and materials gathered by the Department for Children and Families during a joint investigation with law enforcement are considered department records that shall be maintained and may be utilized as prescribed by law and produced in response to a court order. And lastly, information and materials gathered by Adult Protective Services during a joint investigation with law enforcement are considered department records that shall be maintained and may be utilized as prescribed by law and produced in response to a court order. The court is required to bar viewing of the sealed offense in any accessible database that it maintains. The case file remains publicly accessible until all charges on the docket have been sealed. When all charges on the docket have been sealed, the case file becomes exempt from public access. When a sealing order is issued by the court, any person or entity except the court that possesses criminal history records must bar viewing of the sealed offense in any accessible database that it maintains or remove information pertaining to the sealed records from any publicly accessible database that the person or entity maintains and clearly label the criminal history record as sealed. As currently happens, the court will keep an index of sealed cases. Section 7608, victims. Current law requires the respondent to notify any known victim if a petition has been filed. The amendment from your House Judiciary Committee adds email as a method for contacting the victim. 7609 allows a person who is 18 to 21 years of age at the time the person committed a qualifying crime to petition to seal the record after 30 days from the date the person completed the terms and conditions of the sentence for the conviction. The court shall seal the record if the following conditions are met. Restitution is paid in full, and the respondent has failed to show that sealing would be contrary to the interests of justice. Subsection 7610 is in regards to the Criminal History Record Sealing Special Fund, and we'll have our House Ways and Means speak to that piece of it. There were no changes. 7611 is regarding unauthorized disclosure. This section includes law enforcement officers in the list of people who are subject to a civil penalty for knowingly accessing or disclosing sealed criminal history record information without authorization. A violation is subject to a maximum civil penalty of $1,000. Now we're into Section 2, which is the right to not disclose expunged or sealed criminal history records. This section directs the Secretary of Administration to notify all state administrative entities and the court administrator to notify the judicial branch of their obligation to notify persons of their right not to disclose an expunged or sealed record. Section 3 is regarding deferred sentences. Currently, when a person successfully completes a deferred sentence, the criminal history record pertaining to the offense is expunged. The amendment substitutes sealing for expunged. Section 4 is the application to deferred sentences, and this confirms that Section 3 of the Act applies prospectively to deferred sentences issued on or after July 1st, 2025. Section 5 is the expungement of municipal violation records and expunges municipal violations 2 years after satisfaction of the judgment, provided the person has not received any additional municipal violations. This section is modeled after a similar provision enacted in 2021 regarding traffic violations and will apply to municipal violations that occur on and after July 1st, 2025. Section 6 is the expungement of traffic violation records and amends the previously adopted statute requiring expungement of traffic violations to clarify the implementation date. And lastly, the effective date is July 1st, 2025. In committee, we heard from a wide range of witnesses, over 25 individuals that I will not share right now, but I have a list available if folks are interested, and I can speak to any questions regarding witnesses. I have it available here if folks would like. Madam Speaker, the thoughtful and balanced record clearance approach established in S12 establishes a modernized framework for Vermont and creates a clear path for further reforms as progress is achieved. S12 offers a solid foundation for future considerations such as petition sealing, qualifying crime expansion, and the ideal balance of sealing and expungement systems. I look forward to these future discussions in following years. S12, as amended by House Judiciary, passed out favorably with a vote of 11-0-0, and we ask that you join us in our support by voting yes.
And now speaking for the Committee on Ways and Means, member from Burlington.
Madam Speaker, your Ways and Means Committee considered the fiscal impact of S12. Section 7610, to be found in yesterday's calendar, is the Criminal History Record Sealing Special Fund. Now, a person only pays a fee to seal a DUI 1, and no other person requesting expungement pays any fee to seal records. There is no change in S12 regarding who pays a fee to seal records. This bill would only expand the list of qualified crimes, so there may be more petitions for the courts to process and sign. The testimony was that the courts could return to the legislature if they need more resources for processing. So, S12 does not change current fees, and S12's impact is tangential to one fee, a fee for expungement of DUI 1 fees that is not changing, and which, to put it in perspective, brought in $5,400 in 2024, and whose carryover funds remain in the special Section 7610 funds. There is no fiscal note. Witnesses were Legislative Counsel, Office of Legislative Counsel, Associate Fiscal Officer, Joint Fiscal Office, and the reporter of the bill, House Judiciary Committee. Your Ways and Means Committee voted 8-0-3 in favor and asks for your support.
So the question is, shall the House propose to the Senate to amend the bill as recommended by the Committee on Judiciary? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have proposed to the Senate to amend the bill. Now the question is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and third reading is ordered. Now, members, the final bill on our action calendar today is Senate Bill 109, which is an act relating to miscellaneous judiciary procedures. The bill was referred to the Committee on Judiciary, which recommends that the House propose to the Senate to amend the bill as printed in today's calendar. The member from Burlington, Representative Rachelson, will speak for the committee. And affecting the revenue of the state, the bill was then referred to the Committee on Ways and Means, which recommends that the bill ought to pass in concurrence with the proposal of amendment recommended by the Committee on Judiciary. The member from South Burlington, Representative Burkhart, will speak for the committee. And then carrying an appropriation, the bill was then referred to the Committee on Appropriations, which also recommends that the bill ought to pass in concurrence with the proposal of amendment recommended by the Committee on Judiciary. The member from Underhill, Representative Squirrel, will speak for that committee. Please listen to the second reading of the bill.
S-109, an act relating to miscellaneous judiciary procedures.
Member from Burlington.
Thank you, Madam Speaker. Your House Judiciary Committee has been very busy, as you have just heard, and has diligently worked to bring you this proposal of amendment to this year's annual miscellaneous judiciary bill, S-109. Just to educate or remind members, the House and Senate Judiciary Committees rotate where the bill starts each year. The bill contains several minor or technical amendments related to judiciary procedures. It also contains other issues that fall in our committee's jurisdiction that are considered small. I like to think of it as a Whitman sampler. Just like people look forward to finding their favorite chocolate, but may not be interested in some of the others, this bill is much the same. Each section of this bill is something that is important to some group, department, or group of stakeholders. What might seem like a small or insignificant change in some cases is something important to many other stakeholders. This bill is typically reported out towards the end of session and grows during the session as new items get considered and sometimes added. The miscellaneous bill is comprised of many different types of items, the common denominator being items that are not controversial in our committee and that will be supported by our full committee. Spoiler alert, the vote on this bill was 11-0-0. Due to the number of items and to keep it interesting, I've enlisted the help of most of our committee members to present the bill. You can follow along on page 2870 of today's calendar, and I'll start off with the first view. Section 1 was requested by the Community Justice Director in the Attorney General's office to make several technical changes to the court diversion statute. The changes make clear that the court diversion program is available in all counties and that the program refers to its clients as persons referred to the program. Section 2 was recommended by the judiciary itself and relieves the General Assembly from having to make statutory change each time it changes the number of superior judges. The General Assembly has the authority to determine the number of Superior Court judges, which is currently at 34. But whenever that number changes, the new number must be enacted in the statute. Section 2 amends the wording so that the number of judges can be changed by the General Assembly without needing to amend the statute. Sections 3, 4, and 5 were also recommended by the judiciary, and they all concern the statutes related to the Judicial Bureau. Section 3 amends the statute so that it more accurately refers to violations of 7 VSA 1005, which prohibits both possession and procurement of tobacco products by persons under age 21. Section 4 makes clear that the Judicial Bureau complaint can only be voided by a law enforcement officer if doing so would not be prohibited by another law. And Section 5 corrects language which incorrectly implies that using a fake ID to purchase tobacco is a criminal offense. It is not a criminal offense. It is a civil offense in the Judicial Bureau. So the proper term is civil penalty, not fine. And Section 5 makes this correction. I now yield to the member from West Rutland.
The member from Burlington yields to the member from West Rutland.
Thank you, member, and thank you, Madam Speaker. I have sections 6, 7, 8, and 9 of the Whitman sampler that the member from Burlington referenced. Section 6 was requested by the Vermont Bar Association. It involves the ability of attorneys to access criminal, family, and probate court case records remotely from their offices and computers. Currently, attorneys are able to access these court records only if they travel to the courthouse in person and use the terminals there. Section 6 requires the court to provide licensed attorneys, Vermont attorneys in good standing with remote access to non-confidential criminal, family, and probate court case records. The judiciary also supports this language. Section 7 clarifies an inconsistency in court rule and statute. Under the general rule that applies when attorney's fees are requested in connection with a lawsuit, the court is not required to hold a hearing on the request if the amount is less than 2% of the total judgment. However, the mortgage foreclosure statute requires a hearing in all cases, so Section 7 repeals that language. As a result, the general rule will apply and a hearing will only be required if the amount of the attorney's fees requested is more than 2% of the total judgment. Sections 8 and 9 involve the criminal statute that prohibits possessing or selling zip guns, which are a type of homemade gun, and switchblade knives. The current statute bans possession or sale of a switchblade knife with a blade length of 3 inches or more, but the statute does not contain a definition of switchblade knife. This lack of definition has created uncertainty for persons who sell or possess automatic opening knives, which are knives that look like normal everyday folding knives, but which can be opened with one hand by touching a button or sliding on the knife, or a slide on the knife. Possessing one of these common automatic opening knives is arguably a crime under the statute, so Section 8 repeals the part of the statute that prohibits possession and sale of switchblade knives. Since Section 8 repeals the crime of possessing or selling a switchblade knife, Section 9 requires the court to expunge all existing convictions of the same crime. There have only been 12 convictions for this offense since 2017, and the judiciary indicated that expunging these conviction records would be very feasible. I now yield to the member from Pittsford.
The member from West Rutland yields to the member from Pittsford.
Madam Speaker, I'll go over sections 10 through 15. Section 10 was requested by the Victims' Compensation Board, which awards compensation to victims of crime. Crime victims are able to obtain compensation for any harm, including emotional and physical harm that the victim suffers as a result of the crime. A person who intervenes to assist the victim can also obtain compensation, but the board has been receiving claims from bystanders who claim to have suffered emotional harm while attempting to assist the victim. Section 10 responds to this situation by making clear that an intervener must suffer physical harm while assisting the victim in order to obtain compensation. Additionally, the House Judiciary Committee added language at the request of the Center for Crime Victim Services to make clear that compensation may be available when a person intervenes to assist any of the professionals who are currently protected by enhanced penalties if they are victims of assault. These protected professionals are law enforcement officers, firefighters, healthcare workers, Department for Children and Families employees, and emergency medical personnel. Section 11 is purely technical and was recommended by the Office of Legislative Counsel, which works each year with the publisher to reissue 4 titles of the Vermont statutes so that they remain updated. During the course of that work, a number of needed technical corrections were identified, including the one in Section 11, which deletes an unnecessary subsection heading. Section 12 is purely technical and corrects an inaccurate cross-reference. Section 13 makes the result of a denial of a guardianship petition identical to the result when the petition is withdrawn before the final hearing. Under existing law, the petition is dismissed and the records are sealed when the petition is denied. Section 13 also requires dismissal and sealing when the petition is withdrawn before the final hearing. Section 14 involves the Uniform Power of Attorney Act that the legislature passed in 2023. The act contained an optional power of attorney form that a person could choose to use, but the form erroneously repeated the same language twice. Section 14 repeals the language the second time it appears and replaces it with the intended language, which permits a person to use a power of attorney to create, amend, or change rights of survivorship. And Section 15 is purely technical and simply adds several instances of the word under that were inadvertently deleted from the Uniform Trust Directors Act passed by the legislature last year. I now yield to the member from Castleton.
The member from Pittsford yields to the member from Castleton.
Thank you, Madam Speaker. I'll be reporting sections 16, 17, and 18 for S109. Starting with section 16, it is purely technical and corrects an inaccurate cross-reference. Section 17 was requested by the Community Justice Director in the Attorney General's Office to conform juvenile proceedings statute with Act 180 from last year. Act 180 created pre-charge diversion, which permits the state's attorneys to refer a juvenile to diversion before a charge is filed. To be consistent with Act 180, Section 17 adds pre-charge diversion to the list of options that a state's attorney has instead of filing a charge in a juvenile proceeding. Section 18 was requested by the Vermont Bar Association and the Vermont Attorneys Title Company. Under current law, some defects in a property's chain of title are deemed cured and validated if they have been on record in the municipal land records without legal challenge for a minimum period of time. For example, a deed that was not properly witnessed or acknowledged is deemed valid if it has been recorded in the land records for 15 years without being legally challenged. Section 19 adds one additional item to this group. If a deed, mortgage, lease, or other instrument transfers an interest in real property and purports to be executed by a person acting under a power of attorney or as an agent for another person, but the document creating the power of attorney is not also recorded, then the property transferred is deemed valid if it has been recorded in the land records for 15 years without being legally challenged. Both the VBA and the Vermont Attorney's Title support this language. I now yield to the member from Northfield.
The member from Castleton yields to the member from Northfield.
Thank you, member. Thank you, Madam Speaker. I'll be reporting on sections 19 and 20. Section 19 was requested by the judiciary and corrects the title of the Chief Superior Judge. Under prior law, the title for this position was Chief Administrative Judge. And under Section 20 updates a statute that's still used in prior language. Section 20 repeals a report that is no longer necessary. Under Act 27 of 2023, the Department of Mental Health and the Department of Aging and Independent Living were directed to report annually beginning in 2025 on how the state forensic facility was functioning. However, as we all know, the state forensic facility was never created, and it's unclear if or when it ever will be. Reporting on a non-existing facility is impossible, so Section 21 repeals the report. I now yield to the member from Sheldon. Thank you.
The member from Northfield yields to the member from Sheldon.
Madam Speaker, I'll be reporting on sections 21 through 26. Section 21 repeals the Coordinated Justice Reform Advisory Council, which had been scheduled to be repealed in 2028. The council was created in 2023 to support state and local community-based programs and services consistent with Vermont's restorative justice policy. However, both the chair and vice chair of the council testified that it no longer has the ability to make budgetary recommendations and should therefore be repealed now rather than waiting until 2028. Sections 22 and 23 prospectively repeal two statutes that are scheduled to take effect on July 1st of 2025. The statutes prohibit public inebriates from being incarcerated in the Department of Corrections facility. The effective date of these statutes has been delayed several times over the years, and rather than delay it again, sections 24 and 25 simply repeals the statutes. However, this language already passed the House and Senate in S36, and it is now on its way to the governor. As a result, these sections will be deleted in the amendment to be offered later. At the request of the Attorney General, Section 24 establishes a firearm surrender order compliance working group to develop a uniform process to ensure compliance with court orders to surrender firearms. Current law requires that in certain types of cases, the court can order that firearms be surrendered to a law enforcement officer, a firearms dealer, or another party designated by the owner. For example, the court can order surrender in cases involving relief from abuse orders, extreme risk protection orders, and domestic assaults. Section 24 requires the working group to study and report on the statutory or policy changes necessary to create a uniform process to monitor compliance, support entities charged with storing and returning surrendered firearms pursuant to court orders, and identify a stable and reliable funding source for any additional resources needed to monitor compliance. The House Judiciary Committee added language to ensure that the report addressed proper storage and return of the firearms. The Judiciary Committee also reduced the size of the working group and shifted some of its members to a list of parties that must be consulted. Section 25 reinstates the ability of a court in an adoption proceeding to consider whether a person asserting parental rights has made reasonable and consistent payments to support the minor child when determining whether termination of parental rights is in the best interests of the child. This language was repealed last year at the request of the Department of Children and Families. However, family law practitioners have asked that it be reinstated because a person's history of making or not making child support payments actually can be relevant in an adoption proceeding. And DCF agreed to the reinstatement. DCF also requested that separate statutes concerning termination of parental rights by the state be amended to make clear that in those types of proceedings, as opposed to adoption proceedings, a person's child support payment history is not a basis for terminating the person's parental rights. The family law practitioners agreed to this clarification, which will be made an amendment by adding sections 25A and 25B to the bill. Section 26 is to repeal the criminal penalty for failure of an adult child to support the adult child's parent if the parent is destitute and unable to support themselves. This is archaic and outdated language that has been on the books for decades without being enforced, so it is repealed in Section 26. I now yield to the member from Williston.
The member from Sheldon yields to the member from Williston.
Thank you, Madam Speaker, and thank you to the member. We're nearing the home stretch. I will take us through sections 27 through 31, and there are 39 sections. Sections 27 and 28, which are also in the big bill and the BAA, repeal the sunset relating to a 2023 increase in marriage license fees. Act 19 of 2023 increased the fee for a marriage license from $60 to $80, of which the amount retained by the town clerk was increased from $10 to $15, and the amount of the fee directed to the Domestic and Sexual Violence Special Fund was increased from $35 to $50. The fee increase is scheduled to sunset on July 1st of this year, and sections 27 and 28 repeal the sunset, so the current fee will remain unchanged with the 2023 increase included. Section 29 provides that a prosecutor may appeal a court order to revoke bail using the same process that applies when a prosecutor appeals a release without bail or conditions of release. The appeal is taken to a single justice of the Supreme Court, who may hear it alone or refer it to the entire Supreme Court for a hearing. The order must be affirmed if it is supported by the evidence. If it is not supported, the Supreme Court or a single justice hearing the matter may remand the case for a further hearing or may, with or without additional evidence, modify or vacate the order. Section 30 was requested by the Center for Crime Victim Services and concerns the Earned Time program managed by the Department of Corrections. Under the program, an offender who receives an earned time reduction in sentence must be notified of the reduction no less frequently than every 90 days. Section 30 adds victims to this notification schedule so that a victim who opts into the notification system would receive notice of the earned time reduction at the same time the offender does. Section 30 also includes a language change requested by the Department of Corrections to more accurately reflect that victims opt in to receive notice about changes to an offender's minimum release date rather than to the offender's scheduled release date. Section 31 was also requested by the Center for Crime Victim Services and creates the Victim Notification Task Force to review and improve the responsiveness of Vermont's victim notification system. The task force is charged with studying and reporting to the legislature on the current state of Vermont's victim notification system, including improving victims' accessibility to information, ensuring that the entire victim notification process is trauma-informed, and expanding the use of automated notification systems in order to increase options and maximize communication choices for victims, and for making recommendations for necessary training and resources. I now yield to the member from Brattleboro.
The member from Williston yields to the member from Brattleboro.
Thank you, member, and thank you, Madam Chair. We are on page 2,885 of today's calendar. I am moving on to section 32, which was requested by the Vermont Probate Judges Association, which creates the Adult Involuntary Guardianship Working Group to study jurisdiction of proceedings involving the involuntary guardianship of adults. Under current law, the Probate Division of the Superior Court has jurisdiction over adult guardianships proceedings unless the adult has a developmental disability, in which case the Family Division has jurisdiction. The proceedings have some differences, such as the ability to have a voluntary guardianship in the Probate Division, but not in the Family Division. The working group is charged with studying and recommending whether the two types of proceedings should be consolidated into one court or whether the statute should be amended to provide equal access to voluntary guardianships in both courts. Moving on to sections 33 and 34, which is on page 2,887, these sections both relate to the process when assistant judges request capital funds for county courthouses. So I'm going to explain very briefly that process as it is under current law. So under current law, any county requesting capital funds for its courthouse must submit a request to the court administrator. Then the court administrator is required to evaluate the request based on several statutory criteria, such as whether it relates to an emergency, whether there is a state-owned courthouse in the county that can absorb the activities, and whether the county has consistently invested in maintaining the courthouse. Lastly, the court administrator makes a recommendation to the Commissioner of the Buildings and General Services regarding whether the county's request should be included as part of the judiciary's request for capital funding in the governor's annual proposed capital budget. So that's the current law. So the current law requires each county to include proposed capital projects in its county budget, and it permits, but does not require, each county to establish a capital program and a capital reserve fund. Section 33 adds 3 new criteria to the list of factors the court administrator must consider when evaluating capital funding requests from county courthouses. First, whether the funding request is consistent with capital program developed by the county. Second, whether the project that is the subject of the request has been included in the list of capital projects in the county's budget, and if so, the description of the project included in the budget. And third, whether the county has established a capital reserve fund, and if so, the amount of annual contributions the county has made to the fund. This section does not become effective until July of 2026, so that the assistant judges who will have to make these budgets have time to adapt to the new requirements. In the meantime, Section 34 requires the court administrator and representative of the Association of County Judges to jointly report to the House Committee on Corrections and Institutions and the Senate Committee on Institutions on the progress made to implement these new requirements. Section 35, which is my favorite one because it's short, concerns the criminal penalties for a second or subsequent DUI offense. The current penalty is at a maximum imprisonment for not more than 2 years. And of those 2 years, they must include either 200 hours of community service or 60 consecutive hours of incarceration. That's the current law. Section 35 is attempting to incentivize state's attorneys and defendants to choose the community service alternative to the 60 hours of consecutive incarceration by reducing the minimum amount of hours for community service from 200 hours to 80 hours. Under Section 36, this reduction in community service hours from 200 hours to 80 hours will sunset in 3 years on July 1st of 2028, so that its effectiveness can be determined before the legislature decides whether to retain it. I now yield to the member from Hartford.
The member from Brattleboro yields to the member from Hartford.
Yes.
Thank you. Section 37 creates that the Chief Superior Judge, the Director of the Office of Professional Regulation, and the Executive Director of the Vermont Psychological Association examine and make recommendations to the legislature regarding family forensic evaluators. These are mental health professionals who conduct evaluations and provide information regarding child welfare and parenting matters to attorneys, judges, and state agencies. The Judiciary Committee heard testimony that there are not enough family forensic evaluators, so Section 37 requests recommendations for increasing their numbers. Section 38 creates the Child and Parent Legal Representative Task Force, chaired by the Chief Justice of the Vermont Supreme Court, to study the need and viability of an improved legal representation system for children and families who are involved in the judicial or administrative proceedings concerning children in need of care or supervision, CHINS, or substantiations of abuse or neglect. The task force is charged with assessing and reporting on whether reform of Vermont's legal representation for children and families is necessary by exploring such topics as standards and best practices, compliance with funding and reporting, requirements in order for Vermont to leverage federal funding and use of interdisciplinary model of representation, including pay scales, performance measures, supervision and evaluation processes, and recommended caseloads for attorneys, social workers, and other child and family representatives. Finally, Section 39 provides the bill takes effect on passage with two exceptions. First, the provision amending the diversion program statutes takes effect on July 2nd, 2025, which is necessary to accommodate several other diversion program amendments that will go into effect on July 1, 2025. Second, the provision requiring additional information will go into effect July 1, 2025. Second, the provision requiring additional information in county budget requests involving county courthouses does not become effective until July 1, 2026, so that the assistant judges have the time to adopt the new requirements. And at this point, I revert back to the member from Burlington.
The member from Hartford yields to the member from Burlington.
Thank you, Madam Speaker. I mentioned that our House Judiciary Committee has been busy, and we have heard from 33 witnesses on this bill. I'm going to speed read them. I will not give the title. I will just give the organization for the sake of keeping us moving here. Vermont Federation of Sportsmen's Clubs, Chief of Police, the Office of Professional Regulation, the Vermont Judiciary, the Vermont Parent Representation Center, the Attorney General's Office, the Court Diversion and Pretrial Services Division, Department of Corrections, our beloved Legislative Council, The assistant judge in Bennington County, as well as in Windham County, their assistant judge, Vermont Network Against Domestic and Sexual Violence, Domestic Violence Fatality Review Commission, Tornelli and Hughes Law Office, the Vermont Bar Association, Real Property Section, the Vermont Psychological Association, Department of Children and Families, Department for State Attorneys and Sheriffs, the Defender General's Office, the Center for Crime Victim Services, the Vermont Supreme Court, the Voices for Vermont's Children, an underwriter of title insurance in Vermont, the Family Services Division of DCF, the Center for Family Representation, a former commissioner of DCF, and the Office of Child Support in DCF. As I mentioned earlier, the vote was 11-0-0, and we ask for this body's support.
And now speaking for the Committee on Ways and Means, member from South Burlington.
Thank you, Madam Speaker. S109 was referred to your Committee on Ways and Means because it will affect the revenues of the state. The Joint Fiscal Office prepared a fiscal note that can be found on the House Ways and Means page in the S109 folder or on the JFO website. There are many parts to S109, but only 3 that may affect the revenues of the state. First, Section 24 of the bill requires the Office of the Attorney General to convene a firearm surrender order compliance working group that is expected to meet fewer than 6 times. The JFO estimates expenses for the Attorney General's office related to the working group of approximately $1,500. The bill contains no appropriation for this cost. With regards to sections 27 and 28 of the bill, Act 19 of 2023 included a temporary increase in the cost of a marriage license from $60 to $80 that was set to sunset on July 1, 2025. Of the $20 temporary increase, $15 were used to fund the Domestic and Sexual Violence Special Fund, and the remaining $5 were retained by the town clerks. If we allow the incremental fee to sunset, the funding for the Domestic and Sexual Violence Special Fund would be reduced by approximately $72,000 per year, which represents over 10% of its revenue. And the amount retained by the town clerks would decrease by about $24,000 per year. We heard from the Legislative Counsel from the Office of Legislative Counsel and an Associate Fiscal Officer from the Joint Fiscal Office. Your Committee on Ways and Means voted the bill favorable 11-0-0 and recommends that it should pass in concurrence with the proposal of amendment recommended by the Committee on Judiciary. Thank you.
And now speaking for the Committee on Appropriations, member from Underhill.
Thank you, Madam Speaker. Your House Appropriations Committee reviewed S109 with Legislative Counsel and the Joint Fiscal Office. There are per diems for the Firearms Surrender Order Compliance Working Group, but the costs are de minimis and paid out of the Attorney General's budget. The House Committee on Appropriations favorably recommends S109 as amended by House Judiciary on a vote of 10-0-1. We ask for the body's support. Thank you.
And now the member from Burlington, Representative Rachelson, offers an amendment to the report of the Committee on Judiciary that is printed in today's calendar. Member from Burlington.
Thank you, Madam Speaker. I'm pleased to present this amendment to the report of the Committee on Judiciary. I'm sure you and the members will be happy to know we only have 8 instances of amendment, which I will quickly walk you through. Members can follow along starting on page 2891 of today's calendar. The first instance of amendment deletes sections 22 and 23, which had prospectively repealed 2 statutes that are scheduled to take effect on July 1st of 2025. The statutes, as you may recall, prohibit public inebriates from being incarcerated in a Department of Corrections facility. I know this body will recall this language recently passed the House and Senate in S36, and I've just learned that the governor signed it into law yesterday. As a result, these sections are no longer needed and are deleted in the amendment. The second instant of amendment adds 1 member to the list of parties to be consulted by the Firearm Surrender Order Compliance Working Group, which is a mouthful to say if you have to tell people you're on that group. We are grateful to the member from Franklin for making this suggestion when the bill was deliberated in the House Committee on Appropriations. The amendment adds the Commissioner for Fish and Wildlife to the list of consultees for the Firearm Surrender Order Compliance Working Group, since Fish and Wildlife confiscate weapons at times for hunting violations. The third instance of amendment was also brought to our attention when it was in House Appropriations and also concerns the Firearm Surrender Order Compliance Working Group. We are grateful to the member from Jericho for noticing 2 instances in which the bill incorrectly referred to the working group as a task force, so the amendment corrects that language. The fourth instance of amendment adds new sections 25A and 25B at the request of the Department for Children and Families. Section 25 of the bill reinstates the ability of a court in an adoption proceeding to consider whether a person asserting a parental rights has made reasonable and consistent child support payments. Family law practitioners had asked that this language be reinstated because a person's history of making or not making child support payments actually can be relevant in adoption or sometimes termination of parental right proceeding. And DCF was in favor of making this reinstatement. DCF also requested the new language in the amendment to make clear that their intention was that child support payments are not requested or required for when a child is in custody to pay for foster care costs. The family law practitioners agreed to this clarification, which is made in the amendment by adding sections 25A and 25B to the bill. The fifth instance of amendment makes a grammatical correction at the request of the House Committee on Institutions and Corrections. The sixth instance of amendment was also requested by the Committee on Institutions and Corrections. It adds a member to the Victim Notification Task Force, which was created in Section 32 to review and improve the responsiveness of Vermont's victim notification system. The new member is a person appointed by the Commissioner of Corrections who's familiar with the capability and technical operations of the VINE system, which is a national system and stands for Victim Information and Notification Every Day, or VINE for short. The Department of Corrections uses the system, and victims can sign up for it to download the app and obtain information about their offender. The seventh instance of amendment simply adds language to the reporting requirement for the Adult Involuntary Guardianship Working Group that conforms the report to the working group's charge. The working group is charged with considering whether the statutes should be amended to provide equal access to voluntary guardianships in both the probate and family courts. And this amendment requires the report to address that issue as well. We are grateful to the member from Northfield for this suggestion. The eighth instance of amendment makes several changes to the Child and Parent Legal Representation Task Force created in Section 38 of the bill. The amendment clarifies that the Chief Justice of the Vermont Supreme Court, who also was a witness, is the chair of the task force, and it adds 2 members to the task force, 2 new members, the Attorney General and the Executive Director of State Attorneys and Sheriffs or their designees. The amendment provides that the task force will be studying the need for and viability of an improved legal representation system for children and families who are involved in children in needs of care or supervision, sometimes known as CHINs, or substantiations of abuse and neglect, judicial or administrative proceedings. The amendment removes language that is required of the study to also cover representation in connection with relief from abuse petitions. The rationale being it would widen the scope of the work significantly and involve many other different stakeholders. Instead, that issue will be looked at in a different manner. The straw poll in our committee was 10-0-1, and we ask for this body's support. Thank you, Madam Speaker.
The question is, shall the report of the Committee on Judiciary be amended as offered by the member from Burlington? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have amended the report of the Committee on Judiciary. Now the question is, shall the House propose to the Senate to amend the bill as recommended by the Committee on Judiciary as amended? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have proposed to the Senate to amend the bill. Now the question is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please say aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and third reading is ordered. Members, that completes the orders of the day. Are there any announcements? Members, the chair has two. First, just a reminder that we will be having a caucus of the whole approximately 3 minutes after we gavel out. And we will have a token session on Monday at 2:30. And as a reminder, you do not need to be here for this, and we will be back in regular session on Tuesday at 10. Are there any announcements? Seeing none. Member from Poultney, can you please offer us a motion to adjourn until Monday, May 19th at 2:30 p.m.?
Madam Speaker, I make a motion this body stand in adjournment until Monday, May 19th, 2025 at 2:30 p.m.
You have heard the motion. Are you ready for the question? If so, all those in favor, please say aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and this body stands in adjournment until Monday at 2:30.